Hi Doris, I'm attorney Patricia Claybourne. I'd like to share some information with you in regards to Jamie Davis, who is a 2-year English instructor at your facility. You stated that Jamie is about 6 months pregnant and has been informed by her doctors that she must take immediate leave of absence before the baby is born. Jamie is unmarried and single, and she wishes to take FMLA. In your conversation with Ms. Davis, I believe you stated, and I quote, "You must resign because you would be setting a poor example for our students." Jamie refused, and now you wish to terminate her employment. First, I'd like to share some information with you about the FMLA and the PDA, the Pregnancy Discrimination Act. The PDA prohibits discrimination in all aspects of employment. It prohibits policies that limit or prevent women from doing jobs simply because they are fertile or pregnant, but also forbids policies that desperately impact women because they are pregnant or able to become pregnant. Furthermore, the employer, your employer, will need to demonstrate that they do not treat men who are engaged in premarital sex differently from women who are. However, in this case, the FMLA law might be in favor of your employer. Therefore, your employer may counter if Jamie pursues the suit. Ms. Davis is protected under the PDA. If she takes a paternity or maternity leave, her position must be left open for an employee who is on a leave for sickness or a disability. However, she isn't entitled to the FMLA benefits as her employer falls below the 50 minimum employee wage mandatory payroll. I would suggest a mediation of all parties to eliminate any possibility of a horrible legal costs. So let's review what has transpired. As headmaster of the school, you threatened to terminate Ms. Davis's employment because of her pregnancy, and you insisted that she was setting a poor example for your students, and unfortunately that statement in itself is a threat and a violation of her civil rights. Jamie has a cause for a suit. However, under the law, Ms. Davis is covered and protected under this right, and she cannot be fired because of her condition. If so, she has the right to file a discriminatory suit against you and the school. If such a thing transpires, it's possible that the suit can be in favor of Ms. Davis and possibly cost your employer a horrific amount in punitive damages. On the other hand, under the FMLA law, Ms. Davis is not entitled to paid leave because of her employment situation. Her employer doesn't meet the qualifications of a full-time 50 employee staff requirement in order to enforce this particular law. Your employer needs to understand and should be informed of their rights and of the employees' rights as well, as they are stipulated and mandated in the FMLA and the PDA policies. I would recommend mediation again with your HR department. A conflict or resolution counselor should be also in the midst, Ms. Davis and yourself, if she so desires. There are some things that you can probably offer to Ms. Davis on your employee's behalf so that you can try to encourage her not to file suit against your company. Since Skyline cannot fire her simply because she is pregnant, perhaps Skyline would be willing to negotiate, since the threat of firing her came from a representative of their organization, that being you. By the PDA law, threatening termination because Ms. Davis, who has informed you that she was pregnant and has developed a serious condition during her pregnancy and had been mandated by her physician to discontinue working immediately, is illegal. I would recommend, again, mediation and possible negotiations to refrain from going to court and accumulating any expenses on both parts. Also, negotiate so that Mrs. Davis and her unborn child are accommodated through and after the delivery, and possibly offer a promise that her job will be intact when she returns upon NPDA law. If the Skyline would offer her some other position temporarily that she can perform at home until the delivery of her baby, and suggest that she can accrue her PTO time and her sick time until she's ready to return to work, that will be another option. Again, I feel Ms. Davis has a strong case of discrimination under the PDA law. However, your employer doesn't employ up to 50 employees within the organization, so the FLMA Act will not support Mrs. Davis's possible suit in regards to the paid time off before and after her surgery. So ask them to consider these findings, and perhaps with these offers, Ms. Davis may be willing not to file a wrongful termination or discrimination suit against your company. Try to negotiate instead of going to court and incurring all these expenses. Let me know if there's anything that I can do to help. Thank you.